And I want to make it abundantly clear that there are two levels of issues here. The first level of issue, where there is no debate, no denial, and recorded for all times in Hansard, is that the Parliament passed a particular bill into act which did not come into law and which ought not to have come into law within a particular time frame, and certain assurances were given to the Parliament, and those assurances were betrayed. That brings us up to the 28th of August. Our issue, which caused the roundtable to be put together as a body of citizens and leaders responding to actions of the cabinet, has to do with the proclamation into law of an act which created a benefit for persons who have since sought to accept that benefit. We sought to get explanations from the government as to why it did what it did. The government has reacted, has responded in a variety of ways, two of which should be noted. One, the head of the government passed up 3 opportunities to speak on the parliamentary record in this matter. There was the Parliament's session to repeal. The head of the government did not speak, so there's no record in Parliament. It went to the Senate, did not speak, there's no record in the Senate. And the opposition moved a motion of censure against the office holder, whose responsibility it is under the Constitution to prevent this from happening as a legal conundrum. The Attorney General, the Prime Minister, did not speak in that debate. Alongside that, one member of the cabinet was dismissed on the grounds that it was all his fault. But the evidence and the information available in the public domain, with which you're all familiar, would point to the fact that there are other persons who are culpable, and in fact the responsibility is that of the entire cabinet. And the office holder who is responsible for the cabinet and the cabinet's conduct is the Prime Minister. The government since has been trying all kinds of things, distractions and otherwise, to have the country accept the government's story. We have put to the President of the Republic that the summary of this situation, is that a group of office holders, mainly members of the cabinet, have conducted public business in a way that opens the cabinet to allegations which we are making, that the cabinet has been involved in conduct inimical to the public interest. In fact, the President of Trinidad and Tobago has now been officially informed by the opposition, supported by members of the table, that the cabinet of Trinidad and Tobago now face an allegation of being engaged in criminal conduct, a conspiracy to undermine the rule of law, involving the use of the Parliament, the Cabinet, and the Office of President to create a situation where the single beneficiaries of all these actions and involvement of these offices of state is to bring about a situation where persons known and favored by the government will escape their day in court. It matters not whether the government agrees with us or not. These are the allegations that we have put to the President, accusing the government of Trinidad and Tobago of being involved in this. And the evidence will bear it out, whether we are right or wrong. We have gone to the President under Section 81 of the Constitution, because so far, in all the conversation in the country, there's one question which the government has studiously evaded, and the question remains this: why did the Cabinet extract Clause 34, Section 34, and proclaim it into law prematurely? It has nothing to do with how the vote went in the parliament. It has nothing to do with whether the Chief Justice was informed, or whether the DP was informed, or whether Justice Rowley lied. It has to do with an answer being required from the Prime Minister and the Cabinet. What was the reason for extracting Section 34 and proclaiming it into law in the way it was done, outside of the rest of the law, which comes into effect in January? When we look at the evidence and the information in front of us, and if you look at today's Guardian's front page, you will see the effect of it. We're still asking why it was done, but we know the effect of it. The effect has been to stymie the preliminary inquiry in the Piaku matter, which has a date and had a date in court in September, and a few days before that date in court was arrived at, the Cabinet took action which had the effect of ensuring that this preliminary inquiry could go no further. That is playing out in the court. But the proclamation in August can now be seen clearly for what it was meant to do. And nothing that the government has said so far has been able to change that. That the preliminary inquiry now falls victim to the proclamation. If that proclamation had come within the time frame given to the Parliament, it would have had no effect on the preliminary inquiry in which persons favored by the government were involved. Section 81 of the Constitution is very clear. It says that the Prime Minister is required, at the request of the President, to provide to the President a report as requested by him on any aspect of actions of the government of Trinidad and Tobago. In short, on any matter which the President thinks in his own judgment deserves information from the government, under Section 81, the Prime Minister is duty-bound to provide answers to the President with respect to any matter involving the government of Trinidad and Tobago. We have written to the President a summary of this matter of a bill going to the Parliament, being enacted into law, being assented to, being proclaimed by the Cabinet under false pretenses, being proclaimed against a background of assurances given to the Parliament, those assurances being ignored, and an Attorney General's action in late November, which, if when taken into account by his actions in August, that the Attorney General would have known when the proclamation came before the Cabinet, the Attorney General of Trinidad and Tobago would have known that if that proclamation was done before the preliminary inquiry hearing in September, he would have known that nothing could have happened in the court because the proclamation would have killed off what was going to happen in the court. Against that background, we have said to the President that we, the people of Trinidad and Tobago, who have had no accountability on this matter, we've had bombast and obfuscation and outright lies from the government and strong efforts at persuading us to move on, and blame being placed on one individual when more than one individual is involved. And that we are asking the President to look at this matter and seek to advise and defend the population under Clause 81 of our Constitution, where he has the power to call the Prime Minister to account for her government's actions. We know that the Prime Minister, having not reported to the Parliament, as is normally required in any civilized democracy, where a matter like this coming before the Parliament, we would have expected the Prime Minister to report as the executive is required to report to the Parliament. under our system of governance, the executive is required to report to the Parliament. The Prime Minister of Trinidad and Tobago studiously failed to report to the Parliament on the action of the Cabinet, which was tantamount to an undermining of the rule of law for the benefit of friends of the government in power. In that scenario, having failed to report to the Parliament on this matter, or to put anything on the records of Parliament, she then purported to address the matter by conducting some investigation of her own. We drew to the President's attention that under our system of jurisprudence, no person against whom an allegation is made, the person who is assumed to have committed the offense, can be the person who is going to investigate the offense and make a determination as to what the outcome of the offense is. So the Prime Minister's purported investigation of this matter is wholly unacceptable and in a requirement to respond to the President if the public interest is to be served, and if Section 81 is to protect us, and if the basic tenet of our jurisprudence is to be observed. Members of the Cabinet of Trinidad and Tobago, including the Prime Minister, would be required to answer questions on this matter of the proclamation of Clause 34, and we ask that they be answered under oath. Because if those matters are not answered under oath, then this population will never for all times be able to understand whether or not